Okay, folks, it's 2:45. It's time for the last session. I'm David Longenecker. I'm the president of the Western Interstate Commission for Higher Education. Some of you may not be familiar with WICHE or the other three regional compacts that exist in the country. We're not the regulators. What we are interstate compacts. In WICHE, our mission is a very simple mission. It's to expand access to high-quality post-secondary education for the citizens of the West. We do that through collaboration between states and institutions when collaboration makes sense from both their perspective and ours. I'm going to talk to you today about a nightmare that we believe that became a dream. A solution became a dream for some of us, and it's now a reality. And it's called the State Authorization Reciprocity Agreements. Sarah, I'm put up here, Sarah to the rescue. That wasn't my invention. I actually borrowed that from one of those groups that provides webinars at substantial expense to you folks. I'm going to give you what I think they probably presented today for nothing. And I'm going to talk to why Sarah has evolved and how it has evolved so that you have a sense of what's coming forward in this new arena of state authorization of institutions of higher education. I'll just mention, this is actually sort of my swan song from doing this. WICHE has been very active in the national discussions of this and in the evolution of this concept of the state authorization reciprocity. But it's now being essentially handed off. Each of the four regionals, including WICHE, will be involved in it, but there's also a national council of state authorization reciprocity agreements. We've hired the executive director of that, Marshall Hill. Marshall was the state higher education executive in Nebraska, came to NC Sarah to run it, and probably Marshall should be here, but I kind of like your organization, thought a trip to Vermont would be really cool. And so I kept this one in my bailiwick. So I'm going to talk first about why it was necessary to essentially do something in this arena. As some of you may be aware, this isn't the first time there's been discussion about the states coming together. In the mid-1980s, there was an effort called ALTEL, where the state higher education executive officers tried to find a way in which the states could work together. And after a very substantial amount of effort, were unable to secure that. Some of you will remember in 1993, coming out of the Higher Education Act of Amendments of 1992, something called the State Post-Secondary Review Entities, SPREs, which were proposed. And the states were working hard to come up with ways to comply with the federal regulation on that. Then there was the some called it the Contract with America. I called it the Contract on America that came out of the Gingrich Revolution in 1994. And one of the first things they did was eliminate. They didn't believe in regulation, and they eliminated the SPREs. And now we have this effort, which really evolved in great part from what the federal government was doing about 3 or 4 years ago. So partly what created the impetus for STERA was the federal imperative that the states become much more active in doing the job they were supposed to be doing. And what this did, in part, is it raised heightened awareness of what the states were supposed to be doing, but many weren't, and what the institutions were supposed to be doing. And the Department of Education's statements were that the states had a responsibility for consumer protection and for regulating the institutions that operated within their states, and that was the law, and that all institutions had to comply with that, and that applied to online offerings just as it did to those institutions with a physical presence in their states. That was news to a lot of institutions that were operating outside their states through online education. They were not aware that they needed to be authorized to do that. And in fact, I'll come back to that in a little bit. Now, as you're probably aware, that mandate from the federal government to some extent was eliminated. They came out with regulations saying, this is our interpretation of current law, and so here are the regulations on what you have to do. And it gave certain deadlines by which all institutions would have to demonstrate that in any institution in which they had students, or any state in which they had students, they were authorized to operate. And that was all occurring around 2010, 2011. The deadlines were initially immediately, and then they delayed them to 2013, and then later to June 30th of 2014. But there was this mandate, and the court essentially rebuked the Federal Department of Education's activities. But they didn't say that the federal government didn't have authority to do this regulation. They just said they had gone about the process incorrectly, that they had not essentially done this appropriately as they should have through negotiated rulemaking. So they are in the process of essentially dealing with this through negotiated rulemaking at the federal time. Now, at that same time, institutions, particularly the for-profit sector, became very upset with this, and they raised a considerable amount of concern in the Congress. The Congress has indicated it may take some actions on this, but it has not done so since that period of time. The Education Department's response to all of this has been to say that they believe this has always been the law, that they require the federal government, or they require the states and the creditors to be partners in what they call the federal triad of quality assurance, which is that the federal government will look at the financial integrity of the institutions, the accreditors will look at the academic integrity of the programs being offered, and the states will ensure and protect consumer protection. So that's sort of what the federal triad is supposed to do. Some of the states took that job very, very seriously. Others did not take it terribly seriously. And so that is what led to the current the dilemma that we have. And the process we have in place, we still have it today. We will have a different process by next year. But the institutions simply can't afford the complexity and expense that the current rules taken to their extreme would impose on them. Neither can the states really afford this. The state offices that do this, think about the job that they suddenly had. They thought they were supposed to be regulating the institutions that had a physical presence in their state. Some of them actually did go beyond and use this as a profit center for them in their states, but most didn't. And suddenly they were told by the department that every online institution needed to have certification from the state that they were authorized to operate in those states. A state like Nebraska, where Marshall Hill came from, he had been dealing originally with probably about 20 institutions. Now he was looking at potentially dealing with 3,000. And he had to hire somebody to basically respond to all the letters that were coming in on this, even though the letters said basically, you're authorized to operate in this state because we don't authorize out-of-state institutions to operate. Something to that effect. What that really also meant that for all practical purposes, there was no consumer protection involved for those students operating outside the state, outside the institution, or the institution states. And what it meant then, therefore, is we had overall an inadequate system of consumer protection for students in the country who were in online programs. I should mention, it's quite interesting because the institutions, we've done some research at WICHE through our WICHE Cooperative Educational Technologies, and we found that particularly in public institutions in the country, many of them had no idea that they were expected to be authorized to operate somewhere else. Their perception was they were public institutions. They were recognized by the state, they were eligible to operate, and their presumption was that that authority expanded outside of their state just as it did inside the state. So they really didn't see themselves ever being subject to another state's oversight, even if they were operating things within those states. So this came as a surprise to many of those. Right now, I would say that there are those that are not aware of what they're supposed to be doing, and there are those that are pretending not to be aware of what they are supposed to be doing. And then there are those that are trying to find a way to be in compliance with all 50 states. North Dakota, the North Dakota System of Higher Education is spending $750,000 a year in securing the authorization for its institutions to operate, its 7 institutions to operate around the United States. That does not account for the staff that they have that are trying to determine what it takes to essentially get those institutions authorized, because each state has different requirements. So if you look around the states right now, what you will find is we have about 3,000 institutions that are doing online education of the 5,000 or 5,500 that are authorized to provide student financial assistance. So we've got, this is just 3,000 dots in the United States. I'm just trying to make a point here. This isn't where all of those institutions actually are. South Dakota, North Dakota wouldn't look quite like this. Some of the other areas would have much more overlap, but that's 3,000 institutions in the country. And at the present time, each of those would need to have authority in the 50 states. This is essentially the regulatory environment that we face today. That doesn't make any sense. It's just far too complex for institutions to know enough about what the 50 states differentially require and what the fees are for, and then pay the fees for those, or for the states to really be able to look at those 3,000 institutions. It's not a viable way of looking at the world, and yet the Department of Education has a reasonable reason for expecting that the states will be overseeing these institutions. It's part of that federal triad, and it is a state responsibility because it's not in the Constitution that it is a federal responsibility. So that's why this has evolved as such an important issue. And the states believe it's their responsibility, at least for their institutions. So the concept really of SARA developed out of 3 separate activities. The first to begin was one that was put together by a group that's called the President's Forum, which is a group of both public, private, for-profit, private, not-for-profit, primarily online universities. And it's a group sort of operates out of Excelsior College in New York. And it, working with the Council of State Governments, received a grant from the Lumina Foundation to try to find a way in which the states could work together. So they were thinking about a nationwide or a national answer to this. And Council of State Government does national interstate compacts. It's part of how we do our driver's licenses and things like that, and accept those. Those come through interstate compacts. Shortly thereafter, the 4 regional organizations, higher education compacts, which 3 of those were originally chartered by Congress in the 1950s. So we've been around for a long time. WICHE is celebrating its 60th anniversary this year. So we've been working within our regions with public and private institutions and with the state governments. We are quasi-governmental activities. We are all established as 501c3 nonprofit organizations, but we are quasi-governmental. In my case, all my commissioners from my 15 states and 1 territory are appointed by their governors, and that we receive dues from the states, as do all the others. So we have a strong relationship to the state government. So we felt this was something that logically we could do reasonably well because we had relationships in our regions. And we didn't, frankly, want to have another higher education compact going to our legislature for dues. We want to be going solely to our legislatures for dues. So there was a self-interest for us to be involved. But we also felt that this would be better done at a regional level than at a national level. And we started this in the West. We were very active early on in this because an organization we work with that are provosts of our regional universities actually asked us to take this task and to create a regional compact, or this as a function of what we were doing. So we were the first in, but we invited our sister organizations, the New England Board of Higher Education, the Southern Regional Education Board, and the Midwest Higher Education Compact to think this through with us. So they attended all of our meetings, steering committee meetings, and helped us develop the framework for this. They then all adopted that. And we had that working against, if you will, at one point, the President's Forum CSG efforts. And so we began then working with those, with CSG the President's Forum to find common ground for the two of those. There was a third organization that was beginning to come together on this too that was very interesting, and it was the National Commission on the Regulation of Post-Secondary Education. It was really established and put together by two major organizations, the APLU, the Association of Public Land-Grant Universities, and the SHIO organization, the State Higher Education Executive Officers. And they, interestingly, were kind of strange bedfellows because APLU, the land-grant colleges, were those institutions that said, who the hell do they think they are? We know, I mean, we're the public land-grant universities. We were chartered by Congress. We're the ultimate institutions of higher education. Who in the world thinks they should be overseeing us? They really thought this regulation should just plain go away. And then there were SHIO, which were the State Higher Education Executive Officers, who in many cases are the regulators in the states, so they are more familiar with this. They actually got started late in the game here, in part because of a personal tragedy. Peter McPherson, who's the president of APLU and really was leading this effort and was promulgating it, his wife had a stroke. He was really devoted to his concerns about her and her health for about 6 months. So they've trailed the rest of us. Fortunately, she recovered very well, but it did delay the start of their effort. Dick Riley co-chaired that effort with Peter McPherson, and so we took our product to them and said, think about this as an approach. By then, the President's Forum, CSG, was agreeing with us that the regional forums or regional format would work out. They came to believe that made a lot of sense too, and in the end, last April, in their final report, it was one that all three organizations endorsed, and it essentially called for establishing this SARA network that I'll describe in a moment. So it is a national voluntary network of states accepting the approval of institutions from their reciprocity states. So this is going to be voluntary for states. They don't have to join. This is potentially one of the problems with the solution. But it's a voluntary system that states will join, and if they are in any one of the four regional compacts, SARA organizations, they will be accepted by the other, whoever's in one of those four, you'll be accepted. Now, our hope is that this idea has such strength and such value that it will, for all practical purposes, become a mandatory voluntary activity. States will not have to join, but they'll have substantial value for doing so. Likewise, for institutions, it is voluntary. So even if they're in a state with this, they don't have to join. They can continue to go to all 50 states to get their approvals, or they can continue to essentially ignore the law, but it will be increasingly difficult to ignore the law and pretend that you don't know about it because there's so much visibility of this. The giant has awoken. And so it's really going to be very difficult to argue ignorance on this. The states will be going through their respective four regional compacts. The activities of the four regional compacts will be coordinated by this National Council for State Authorization Reciprocity Agreements. The National Council will do three things. It will make sure that the four regional compacts, like the one I run, are acting in ways that are compatible with each and comparable to each other. So we don't have some states that are getting away with murder and other states that are being expected to do outrageous things. They will approve our documents and activities. And in fact, that will be, we've all recrafted our founding documents to be consistent with the National Commission's document, and that will be the first action of the National Commission, which has been selected and will meet on November 1st. And they'll be looking to make sure that we're all compatible. If we're not, they'll be asking us to make changes to make sure that we are. So that will assure that there's oversight. That's the first and most important job of the National Council. The second one is they will manage the resources of this, and I'll talk about the resources at the end. And the third is that they will provide a national database so that any state, any institution, any consumer will be able to go and find out whether an institution in a state is covered by one of the SARA agreements. There were two principles that drove our actions in the West and to some extent became a part of the overall structure. The first was that trust was really imperative in having interstate reciprocity agreements. And trust is a really difficult thing to get in public policy, but it's absolutely necessary. And you need trust between the states that are seeking the reciprocity. And this is why some states initially will not come in, is they do not, the states that have been the most rigorous, or what they would call rigorous in terms of oversight, do not believe that our standards are tough enough. Now, they call it rigorous, other people call it other things, but the fact is some of the states were much more significant in their activities in this area than other states. And they're afraid that we're going to let bad actors slip through in certain states. The second is there needs to be trust between the three actors in the federal triad. So we have to have trust between the states, the accreditors, and the federal government. And we need to make sure that we're comfortable with them. And if you look at the documents for SARA, it says that states will accept regional or national accreditation as sufficient initial evidence of academic quality for participation in SARA. There's a lot of the states that are anxious about this don't like accreditation. They do a quasi-accreditation themselves. Those states will either have to get over it or they won't participate in this program. The federal government is quite comfortable with this. We worked very closely with them. They will be accepting this, but we've also accepted that the federal judgments with respect to financial responsibility will be the financial responsibility test for participation in SARA. There are certain institutions, particularly independent institutions, that are not comfortable with the federal assessment of financial responsibility. Those institutions probably won't be comfortable in reciprocity. With respect to the regulation, that was our second mantra, is that we said less is more unless it's not enough. And this was really pretty tough. I mean, many of the states do not believe less is more. They believe regulation. It's my own sense in public policy that there's really been a sea change in the concept of what regulation should achieve in this new century. And that we're much more focused on outcomes than we were on process, that we're much more focused on what's necessary and not what is the top of the line. And so we generally believed that we wanted to make sure we had reasonable standards, sufficient standards, and nothing more than was necessary. There are certainly states that don't agree with that philosophy, at least today. Now, we also said that if a state wants to do more, that's fine. A state can do whatever it wants to do with the institutions in its bailiwick. It can be as onerous as it wishes to be. But it must be willing, if it's going to operate in reciprocity, to accept states that meet our standards, but they may not be as rigorous as their own states. So they'd have to, if they join reciprocity, they have to be willing to accept what another state has done. This is an artist's rendering. It wouldn't be mine because that's not where the 4 regional compacts are. It's just to try to say that there will be 4 regional SARAs. There's W-SARA, there's M-SARA for the Midwest, there's N-SARA for New England, and there's S-SARA for the South. Of course, the best is W-SARA, of course. And essentially what we've got is the country broken up in those 4 ways. So a state will essentially approve this, they'll come in, and then they'll have reciprocity cross. One of the dilemmas, of course, is that there are 3 states that don't belong to any of the regional compacts: New Jersey, Pennsylvania, and New York. And they're pretty important states. they're essentially a major portion. Yes?
May I ask, does this regulation, and this is something does this regulation come down to the territory?
Yes, it does.
Like Puerto Rico?
Yeah, territory, the Guam, Puerto Rico does not belong to a territory. Guam, American Samoa, and Northern Marianas are members of WICHE.
So Puerto Rico?
Puerto Rico would have to do what I'm going to explain that New York and New Jersey and Pennsylvania will have to do.
Not be a part of it.
Well, it will be, if it wants to be. We had to come up with a way. We couldn't leave out three of the largest states and most important states, for those of you, of course, who are from New Jersey. New York and Pennsylvania, you know you're amongst the most important parts of America. We had to have something for those states, right? So what we came up with is they can choose to join any one of the 4 regional compacts for purposes of state authorization. And there's a fee of that, $50,000 a year, which is much less than the actual dues that any state pays currently to belong to one of our 4. Or they can, if they wish to, join the compact in their regional area. Now, if I had my druthers, we would have said they would all go to the New England Board of Higher Education. But we said they could join any one of us. We've actually got one talking to us. They're wonderful folks. I've encouraged them to look at the New England Board of Higher Education. I will tell you, the New England Board's current leadership is the strongest regional organizational leadership in the country. Michael Thomas, who's the president of the New England Board of Higher Education, is really exceptional, so there shouldn't be any concerns. They will do a good job in this regard. So they can join for a fee any of the others if they wish to, and I think they will. Yes?
If someone is at an institution that is in one of those states,
They're screwed unless they join one of the other things. That's true in any case. That this is voluntary on the state part and on the institutional part, but an institution can't join unless its state is part of reciprocity, because it's the state regulation that is a part of this. And that's why we think there's going to be a substantial amount of pressure on the part of these institutions. New York's a great example. New York has never liked the idea of having anybody from outside New York offer any programs in the state. So you don't find the University of Phoenix or others offering programs in New York State. But now, and that really satisfied the in-state institutions, which really like to have sort of a captive audience. Now that will change, because now SUNY will very much want to be able to take its online programs to other states, but the only way they can live with that is to accept that others from other states could come into their state as well. So that is where we see a lot of the pressure. The major opposition to this, incidentally, has come from the state authorizing entities, which by and large, particularly in those states that have rigorous activities, and I could even tell you which states the major opposition has come from: Massachusetts, New York, Minnesota, Arkansas, Tennessee, Florida, because they had pretty substantial, rigorous standards, pretty expensive ones. So they generated a lot of revenue from this as well. Now the pressure on those will be from their institutions in those states that will say, gosh, and this has already occurred in Maryland, if there are any folks from Maryland here. Maryland was one of those states, but the University of Maryland and University of Maryland University College have said, we've got to have this. This is save us a boatload of money. And so that's where the sort of tension is going back and forth. Yes?
So if the state is currently part of one of the compacts,
Yes.
Is it a separate decision for the state then to be part of the ceremony?
Yes, they have to meet certain standards and come into this and approach. I'll give you a timetable in a second about how they'll be able to do that. So this is sort of, then those 4 compacts will work with the National Council which will make sure that we're essentially comparable in meeting the standards that we've all agreed to do in the past. So let me talk a little bit about the funding strategy for this. This is going to be a substantial activity. It's got to be financed. At least initially, it's being paid for by the Lumina Foundation. They provided WICHE, a major grant. We are managing both the WICHE SARA and the National SARA at WICHE. We were the most actively involved of the 4 regionals. I was actively involved in a lot of the discussions, and so we made the pitch for the funding, and it came to WICHE. So we're operating 2 entities right now. The National SARA will eventually become a separate organization. To have sustaining funds, this will be paid for by the institutions that participate. The states won't have to provide anything, but the institutions will essentially, if they're a small institution, they have to pay. These haven't been adopted. They'll be proposed to the National Commission in November 1st and probably adopted. I'm pretty sure this is what we'll end up with because our projections suggest this is what we'll need to sustain the organization over time. So if you're a very large organization, it'll be $6,000 per year. Smaller organization, $2,000 per year. Mid-size, $4,000 per year. Now that's less than an institution currently pays in about half of the states where they're authorized. So it's a very inexpensive alternative compared to what they're having to pay today. Not only that, they now only have to be approved in 1 state if all the states come in. Okay, so here's the implementation schedule. We got our funding from Lumina in August. We hired the national staff, the national director in August, and selected a board at a meeting in August. The 3 organizations that I mentioned earlier got together, and we hammered out a board that's 21 individuals. We've now hired all of the regionals have hired their staff, and we've hired all of the national staff. Very outstanding staff. The National Board will have its first meeting on November 1st. We expect them to essentially create the organization, the bylaws and those things. Review the 4 statements from the 4 regional organizations to make sure that they're comparable. If they're not, to suggest ways in which we have to make changes, and to establish the fee structure so that we can move forward in bringing states on. All of the regionals are planning regional forums this fall or early this winter, as is the President's Council CSG. They're going to do some national forums that people will be able to attend if they wish to. And we're actually expecting in the WICHE region that we'll be at the point of accepting states by the end of the calendar year. So we hope to have some states in by the beginning of January. We really are hoping to have the majority of the states in by July 1st of 2014 so that they are in compliance with the federal law that goes into effect at that period of time, because that's the delayed date that the commission, the department provided. So here are the major changes from where we are today for institutions and for states. For institutions, the major change is that all institutions must accept state authorization for online institutions. This is public, private, and nonprofit. This is really a very different scenario for most public institutions. And I don't think most of them, even today, even those that have supported this, fully comprehend what this means. This means that the University of Colorado, our offices are in Boulder, Colorado, so I'll use Colorado as an example, that the University of Colorado will have to accept oversight from another state agency of its online activities if it wants to operate. Now, it can be that states can have more than one state authorizer. So in California, for example, we're talking with California. I'm expecting, well, I'll use Nevada as an example. In Nevada, they'll have a separate agency for all the private and nonprofits, and then all of the public institutions, because they're governed by one board. The feds allow a governing board, multi-institutional governing board, to be the authorizer if they wish to be. And so in Nevada, I know that they'll have 2. Then they have to figure out which one is going to work with the SARA. Both of them, we can't have multiple agencies representing a state, so we'll have to have one that accepts that responsibility. But there will be multiples. But it means that every public, their word isn't good enough. They're going to have something that's overseeing them to make sure that they meet all of the standards that are established for participation. It's going to be new for exempt private institutions. Many of your private institutions in this room are currently exempt from your state authorization because if they're a certain age, they're exempt. If they existed before the country, the U.S., they're generally exempt. There's all things. Those institutions can remain exempt for state purposes, but not for reciprocity. Other states don't accept that exempt status. So in California, for example, almost all private institutions are exempt from any oversight. Well, they'll have to provide something in state law that allows exempt institutions for purposes of online distance education to be non-exempt and subject to oversight if they wish to be. It'll be their choice because it's voluntary, but they'll have to do that. Now, from the institution's perspective, so those are the tough things for the institutions to swallow. On the other hand, the institution will only need authorization from their home state to operate in all of the voluntary reciprocity host states. So that's the good news, is they give up something, but they get a lot. And they have a choice on whether they do this. So that's the institutional perspective. From the state's perspective, they need to have the authority to enter into reciprocity agreements. Many of their current statutes don't provide for that. In the West, 5 of our states have already secured that authorization in state law. They did it in the last 2 years. That's Colorado, Washington, Hawaii, North Dakota, and some other state.
Legislatures to recognize the need to make a change.
It's occurred from different avenues. In our case, almost all of it's come from witchy commissioners. And some of those are legislators in those states who carried bills. Others are the state higher education executive officers. That's actually who's done most of the work, is they found a legislative sponsor, and they've carried the language saying, here's the sentence we need that it would allow us to do this.
And our state agency is opposed to this.
Then it's probably not going to happen for a little while, I would bet. You could get legislation that allowed you to do this. I mean, it doesn't require that from a champion. I would tell you, we have our commissioners, and then we also have something called the Legislative Advisory Committee. I think all of the regionals work something like this. I mean, these are sort of our champions in the legislature. I could have a bill on this in every one of our states go through without any trouble from the LAC. We don't want to do that if the state's opposed to it. So what we're going to do is go for the early adopters and let the noise in the community drive the rest to this. So, is yours a Western state? Iowa, yeah. Iowa's got an awful lot of small liberal arts colleges doing a lot of online. I wouldn't be surprised. And so does Iowa, so do Iowa and Iowa State. So down the line, I wouldn't. Yeah, yeah. So they'll need the authority to enter into these. In most states, they will need this in law, and in most states, it's a very simple fix. If you're interested in this, the National Council now staff can provide you, we don't believe in model legislation, but we are more than happy to share the language that other states have used so that you can see whether it fits your state or not. They'll need, the bigger thing is that many states are going to have to change their current regulations and rules to make this possible. That's different than legislation. But for example, in California, actually, they exempt almost everybody. Well, it's not clear that they would need a law. The law doesn't, it exempts these, but it doesn't, I think it's quite possible that they, through rule, could make it possible for institutions to seek non-exempt status without having a law change. California actually will have to change something else. They've got in their law that their authorization language applies only to residents of the state of California. Well, our whole principle is that an institution is responsible for its students wherever they go. So, and they are the home institution. So California will need to change their law to allow it to be the students served by the institutions in California rather than just the citizens of the state. And the other thing many states are going to have to do, and this is going to be one of the tougher hauls, is their consumer complaint requirements must provide for academic malfeasance. Now, many states right now will have very good regulations on everything but anything to do with the curriculum or academics. That is perceived to be the purview of the faculty and the accreditors. The accreditors, however, don't do anything in terms of consumer protection. They will take an action against an institution that they know is violating academic standards, but they will not protect the institution. So they may have a fine or an action against the institution, but there's never a required restitution for the student. And that is something that both the federal government and the states believe is a requirement. So that will be something that many states have to deal with because many of the state regulations essentially punt entirely on academics. But if you got a situation, and it's quite fine, it's quite okay to say, for the state to say, it has to start with a complaint at the institutional level, unless it's fraud. We don't really require that a fraudulent act has to start with a complaint at the institutional level. That can lead to even more serious legal issues. But we do, it's quite fine to say that the complaint should start at the institution, but if it's not resolved, the student should have an opportunity for complaint resolution at the state level.
Would that be for arbitration or mediation?
It can be through those processes. There just has to be a reasonable accommodation. If the student doesn't believe they've received that, they have the right to make a complaint that would then be adjudicated at the state level. And then this is a kind way for saying that it will require different standards for some. This is for those states that are very rigorous. They will have to be willing to accept whatever the regulation is of other states that meet. All the other states will have to meet the standards that are established in the documents, and they're a reasonable set of standards. But they won't be as rigorous as New York or Minnesota or Tennessee or Massachusetts or Arkansas are today. Those are or Florida. Those are the ones that are over the top, not over the top. They're rigorous today.
But would that mean that institutions inside that state, when it comes to teaching students in a classroom, person to person, would that mean that they would have to change their own standards for that?
They can do whatever they want to do in-state. They can continue to be as rigorous as they wish within their own state. But if they want to participate in reciprocity, then they have to be willing to accept what are reasonable standards accepted by the community that are implemented for interstate reciprocity. So that's why there'll be different standards for some. Some of those states will play, and they'll say, Tennessee is a good example. I've talked with the head of the higher education board there, and he says, we've got some guys we have to really keep the hammer hard on here. I said, well, you can do that. Just don't expect that you can put the hammer down on the institutions from all the other states. They'll have a different set of standards. If you're uncomfortable with that, then you shouldn't be coming into this Because the standards we'll be talking about are as high as most of the states have used that do a reasonable job. They're kind of the standards that Colorado, in the Western, for those of you from the West, Washington and Colorado and actually Arizona and Utah have had pretty good regulation in the past. And that's the kind of stuff we're going to impose on everybody else. Oregon was rigorous. And Oregon will have to swallow and accept something. It is, I would tell you, it's happening in Oregon. The executive director of the over-the-top organization was released from her job 2 days ago because the governor's office, which has a witchy commissioner, is devoted to participating in this, and she wasn't willing to, and she's not there, so they'll be in.
This may be more speculative policy than you want to talk about, but one thing that immediately springs to mind is large vendors like Pearson.
Yes.
Packaging online and distance education and branding it with the college's name.
Yeah.
Splitting the revenue, doing everything else, and what you may find happening is that higher education drives ever more quickly towards a purely commercial future.
I'll actually come to that.
Suppliers out there.
Let me come to that in just a minute when I sort of finish this, because I think that is something that's sort of could be the next stage. And while I think Sarah is a really very good, it's not a perfect, but a very good solution to a current problem, it's not clear to me it is a solution to the emerging future problem. We have certain metrics of success that we're focused on. Lumina requires you to have that if they give you millions of dollars. Our goal is to have 50% of the states participating within 2 years and 80% of the states participating within 4 years. I actually think we will easily achieve those metrics and move beyond that. We do not have specific metrics for institutional participation. We do, I will tell you, to be financially viable, we'll need about 750 institutions in the longer term to pay for what it takes to keep 4 regional offices and a national office operating. So we're going to need to make this valuable enough to both the states and the institutions to play in this game. If not, it was a good idea whose time had not come. It's pretty obvious to us, at least from the Western perspective, that there's a lot of support for this. I was at a meeting of institutional leaders, online institutional leaders last week, and at the end of one presentation, the one woman said, "Alleluia," and the response was, "Praise the Lord." We're hoping that this will satisfy the federal government, that they can clean up their regulation, which they need to do, and say, yes, you need to do this, but reciprocity is an acceptable way of doing that. And we have every reason to believe they will do that. We've been working very closely with them. Now, of course, as you're probably aware, almost everybody who was in the federal department who worked in higher education has resigned and is gone. And so the people we were working with most closely are gone. But we're convinced, the Secretary himself has indicated support for this, and the President has as well. So we're pretty sure that they'll be with us on this. So this comes to your point. I think as we look at the future of this, the question is whether the institution is going to remain the object of review in the United States. I mean, it has been. We've always thought of the institution as the unit of analysis for it. But as we look at the things that are happening, we've got MOOCs developing. MOOCs are developing now their own credit-bearing capacity as well and financing structure. We've got these program partnerships, which you just mentioned, which is where, for all practical purposes, vendor or other institution is offering it for this. The Bridgepoint thing is the most recent example of that, but we've got an awful lot of very credible institutions around the country purchasing a lot of material from Pearson's or from Straighter Line, or, we used to outsource all of our non-core activities. We're outsourcing an increasing share of our core activities now, and whether that will drive to some new form of quality assurance or to some chaotic environment where quality assurance means nothing is, I think, an open question. we've got a serious set of issues around licensure. When we began our work, there was some question about whether we should do state authorization of institutions and also look at the many licensing boards, because to some extent, they are significant regulatory burden on institutions as well. But we didn't take that one. It was just too much to chew off. If state authorization was tough, well, we were talking really about one sort of, licensure is many, many different fields, and there's a whole lot. We do this to some extent in teaching and law already. Those are two areas where there's a lot of reciprocity. Not uniform, but quite a bit. But we've got fields in nursing and clinical psychology and in many of the allied health fields where every state has a licensing entity that is doing that work today. And so that, I think, is something that will have to come down the line, because it's creating an increasing administrative burden for you, but also for the professionals and personnel coming out in those fields, that they may be licensed as a nurse, as a registered nurse in Indiana, but they may not be able to take that and operate as a nurse in Oregon. Oregon's got some of the most stringent. Or they may take an online program in nursing in Indiana and not be eligible to sit for clinicals in Oregon. And so this is, I think, a really serious area for us to think about too. And I also think, and this is also related to the question that was raised, we are in an environment where people believe the market clears, and that the market drives everything that is good, and that we don't need regulation. This is actually this is not a new movement, but it is very strong. We believe now in entrepreneurship and innovation. All entrepreneurship and innovation is good. Anything we used to do is boring. And in this sort of philosophy, talking about a regulation of something is generally just considered very déclassé. And whether a regulatory environment will survive this, I think, is a good question. In the House of Representatives right now, there's a lot of discussion about deregulating higher education. The trouble when you deregulate, I can tell you, I was assistant secretary, is that you get a lot of shenanigans going on. And regulation is necessary, I believe, but I think it'll be a very interesting future we face.
Compared to the alternative is 50 regulatory schemes. So isn't this deregulation of
I think this makes an awful lot of sense right now. But there are those who say, maybe we shouldn't have any regulation. I hear Senator Alexander say that to some extent.
Food, drug, and cosmetic, you're saying back to snake oil. But the idea is, well, if people are...
If they're buyer beware, and I had some snake oil, it seemed to work. That's a lot of this is going. So I do think that this is I don't know. I'm not predicting we'll go there, but I think there's an awful lot of noise in the environment right now that could lead us in that direction. I saw a hand somewhere over here. Yes.
A couple questions. Do you see a kind of uniformity in the definition of physical presence coming out of this?
Yes, there's a very nice definition of physical presence that actually we started with 3 different sets of things that we would, and it includes both what physical presence is and is not. It's one of the things that will lead some states not to adopt this, but there were some pretty silly things in there that were physical presence. If you were on a server in a state, you contracted with a company and their server was in a state, that was considered to be physical presence. I don't know quite how those states are dealing with the cloud computing, because as far as I can tell, that might be anywhere. But that's basically a server somewhere else probably. And so there were silly things like that. It also tries to come up with a reasonable set. One of the most controversial was online courses that had a physical meeting. I'll use an example that people brought up. Johns Hopkins offers programs in Texas in medicine and medically related activities. A lot of it's all online stuff. master's degrees in this or that or whatever. They like to get their students together once to give them sort of a human contact, as sort of a gathering. In many states, including Texas, that would qualify as a physical presence. We came up with, if it was less than 20 hours and less than 2 sessions, it wasn't considered to be physical presence. There were some states that believed if it was online, it was online. Never, keep it clean. Never let them see, feel the flesh. And so there's some difference of opinion over that, but we felt that that was a reasonable accommodation, that we weren't really violating anything. So that was negotiated as part of this. But there's a set of, if you go to the National Commission report, or if you send me something, I'll send you our report, which uses exactly the same language, indicates what physical presence is, what doesn't qualify as physical presence. Mm-hmm.
I think that would be used for personal jurisdiction. For example, a student in Colorado who's been taking courses online from Johns Hopkins.
Yes.
Would that student have to sue in Delaware?
Yes. They would actually, that's right. Now, it wouldn't stop any of your state attorney generals from doing anything they so wished. I mean, there's nothing we can do to stop that. We've sort of said that. If a state believes that their residents are being abused by an institution, a state attorney general still might sue that institution, and they could do so. If it was within the higher education reciprocity realm, the way we've written it is that the state that knew there was a problem, that heard there was a problem in their state, would have responsibility to share that information with the other state, which then would have the responsibility for adjudicating that. Right now, none of that's occurring. That's what happened. What really happened is that without this, it wasn't that we had those 3,000 connections, or 150,000 connections, 3,000 institutions, 50 states. It's that we had none of it. And the students who were online students really had no consumer protection. And there was a lot of abuse that we know goes on, and they couldn't figure out where it was supposed to go. When they raised a complaint, everybody pointed to the other guy and said, well, that's that state's problem, it's not ours, or whatever. And so really there hasn't been much in the way of protection unless a state like Colorado, which took an action against one of the institutions in Colorado, which was serving students elsewhere really poorly, unless the state sort of came down on those. And Colorado didn't do that to protect the students in North Carolina. It used that in the court case. It did it to protect online students in Colorado who were getting screwed by the Colorado institution. Any other questions? Mm-hmm.
As we've been working through this for our online programs, it's that definition of physical presence trigger in some states the fact that we have students who are doing a clinical rotation. And that state becomes...
We exclude, it's indicated that those are not considered to be physical presence. Up to a certain point. I think it's X number, 10 clinicals or something like that in the field, or something like that, in another state.
So, I'm sorry.
Go ahead. No, in fact, I wish I had the numbers on that. I'd encourage you to go and look. It's really clearly articulated in the language.
Is that only linked to a clinical rotation that may be related to the program that is otherwise accessed online? Or would that address, for example, we have an online program for post-professional doctor of physical therapy, which has a clinical rotation component along with the online. But we also have doctor of osteopathy students who aren't doing anything online, but they're going out of state for a rotation.
Yeah, that is different. And that one basically becomes more of a licensure issue, whether they can be licensed in that state to operate. That we won't deal, because all we're dealing with is the online program and the associated activities with that. The other issue we wouldn't be able to. There are a lot of states that are just, what they're trying to do is they're trying to protect their clinicals for their institutions in the states. And that's going to become a bigger issue with particularly in medicine because of the rapid expansion of medical schools in the Caribbean, which are buying clinical spots now in hospitals around the country for their students, which is going to constrain, again, the availability of internships and residencies.
But in the interest of higher education as a whole,
Yeah.
I mean, the fact is medical students need clinical sites in which to train.
Yeah.
Or nursing students or
Yeah.
physical therapy students.
Oh, you're right. We weren't trying to solve all of higher education's issues.
So once we get
We're
solved
trying to.
distance education.
Well,
would this be available?
there's already discussion around the issues around licensures, and that will also bring up the issues around clinicals. Nursing's an area that's very significant in that area because there are a lot of online nursing programs. They'll establish a clinical relationship with a hospital, but that doesn't mean that they've got authority within the state to provide anything or that that's going to be accepted by the state.
Is that context of that additional conversation, is that happening in the context of the SARA entities or not?
No, at this point not. I suspect this is where much of it will end up focusing, but I think that will sort of evolve on its own. We want to get this. We didn't want to, I mean, we talked very seriously about attacking those, and we wanted to get something that was clean, by and large acceptable to most communities, and that would make sense. And we didn't want to essentially make it look like we were trying to reform the world. But those are, I think that's a very important issue. It's just not one that we dealt with. Anything else? Well, great. I've given you a gift of 15 minutes. Enjoy that. Thank you very much for listening.